Thank you everyone for coming and sharing your time with us. And your space also in times of COVID, let's say if Zoom is the only space that we have left with. We really appreciate it. My name is Sonali and I work as an editor for Academic, which is a journal by Loctopus. Loctopus and Academic are together organizing a set of talks about marginalization through gender and sexuality. This talk in particular is trying to see the role of law and its relation with love and sexuality. For the same, we have advocate and scholar Arvind Narrain and Mayur Suresh. And thank you so much for coming and thank you so much for gracing us with your presence. Uh, Arvind Narrain is an advocate, activist, academic legal scholar, and founding member of the alternative law firm in Bangalore. Arvind sir has worked on several human rights issues, including LGBTQI persons' rights. He was part of the litigation team that argued the NAS Foundation head of the Delhi High Court and challenged the Kaushal decision in the Supreme Court. Dr. Mayur Suresh is a lecturer in law at SOAS University of London. Dr. Suresh did his doctorate from Birkbeck University of London and has practiced in, I think, Delhi. Please correct me if I'm wrong. Dr. Suresh's contribution in the academic space are well known, especially his work in anti-terror laws, legal text, sexuality, gender identity in South Asia. Dr. Suresh was one of the lawyers involved in the initial challenges to Section 377 before the Delhi High Court and Supreme Court. So thank you again for coming, and it's really nice to have you all with for all the attendees and everyone who is on the panel. Should I start in?
Yeah, thank you for having us as well.
Thank you.
Thank you. I am going to start with I think something that I was speaking to in I was speaking to Vivek Diwan, who's probably going to be a part of another set of talks, and he told me that the moment of Naftage judgment or the decriminalization of Section 377 was combined of many movements of activism. So it didn't come in a day, which we all know. You have written about the struggle of alternate gender reality and queerness and how it started in India. Could you shed some light on the same with respect to the history of how you perceive, and if there is a starting point to...
Arvind, do you want to go ahead?
Okay, I'll begin with on this point. See, if you say starting point of the broadly LGBTI struggle or the queer struggle, you can think of many starting points, and each person you meet will give you a very different starting point based on their understanding of of the history, right? If you some transgender activists might trace it way back to the 1870 when the decision in the case called Khairati was delivered, where a transgender person who was in the description of the code walking ornamentated on the street was picked up and arrested under 377. I think in our understanding that was the first recorded case under 377 was really of a transgender uh, person. So that's one, you can take it back to 1870. Of course, if you're taking it back to 1870, you might as well take it to 1860 and look at the Macaulay Code and how that evolved. And as one of the starting points around which a struggle coalesced. But I think the point for us really, which we want to look at, is what is the legal starting point of the struggle. And the legal starting point really is around the the initial litigation and the campaign around 377. And the first petition was filed in 1994 by the AIDS Bedba Virodi Andolan. Um, that petition did not go anywhere because finally the petitioner themselves uh, dissolved. The second petition was filed in 2001 by NAS Foundation, um, by Laws Collective on behalf of NAS Foundation, and that's one kind of a starting point we can see. And of course, once that starting point begins, then we go back in history and say that what is the work which happens around that, and that's the moment in time when we went back in history to try and look at how what happened in an earlier period in time. And maybe I'll just share one last story and then leave it at that. Is when in the course of doing the research and what happened at the earlier moment in time, I refer to the Khairati case. We found the Khairati case. The other case which we found is a case called Naushirwan, which again is a case of a Parsi man uh, who had a sexual relationship with another young man, and they were caught in quotes in flagrante delicto in terms of in the act, as it were, and charged under 377. Again, if you look back, we can say that's a starting point, because these were guys who were doing what we'd consider completely, as a part of your right to life, right to privacy, right to dignity. Yet they were exposed to humiliation and degradation by the system and the state. And they were maybe the first, we can say, the first unwitting frontiersmen in this struggle. And then just one, I'll make one last point and end with this. And the other starting point one can think of could be, again, we see this in the contemporary moment again and again, right? Where we have these cases of two young women who want to be with each other, who who society doesn't allow to be together, so they decide to run away. When they run away, what happens is the family decides that they belong to us. We want them back. So they file a petition in the courts asking that they be produced back with their families. And in fact, there's one case which we submitted, which we filed before the Delhi High Court, where it's a case of these two women who run away, and the women make the submission: we're adults, we have a right to be with who we choose to be with. And the submission on the other side by the family is that there's in a relationship with each other, and that's a violation of 377. So the judge records that in his order, says that there's an allegation of an offense under 377, and therefore sends them back to their families. Again, this story, again, you can trace it back historically, and you'll find a number of stories like this where two women choose to be with each other, but are picked up, harassed, and separated, right? And so, again, if you're thinking of starting points, there will be many, many starting points.
Dr. Suresh, if you would like to.
Yeah, so I think Arvind, I think both Arvind and Vivek, who you spoke to earlier, are probably right in the sense of thinking of a difficulty of pinpointing where the movement begins, right? In a sense, because there's so many confluences in it. So there's kind of big legal events such as Khairati and Naushirwan. There are kind of all the kind of the filing of the cases, but there are also kind of smaller events, so like such as personal kind of experience that one goes through. So kind of my own entry or my own starting point is just finding a community of other queer people in Bangalore, right? And I think I remember my first interaction was with the biggest group of queer people I know was with Sangama in Bangalore, where I attended, I forget what it was, some kind of community meeting, and people are talking about everyday life, and the law came up almost marginally, but it was about how they spoke about criminalization, harassment by the police, but also about fun, who was hot, who was not hot, who'd we fancy, who do we not fancy, stuff like that came up. And so really for me, in terms of starting point, was finding a community, and finding the words in which to speak about myself, and also the words in which to speak about the law, right? So I think for me that was a starting point, and then you kind of, as one grows, one finds one community is a lot larger than one's immediate peers. So you meet friends, as in I made friends from around the country, and you hear of the kind of the issues that people have faced, from street harassment to being beaten up, to being discrimination. So then you kind of put those experiences together in some sort of legally coherent way, and you come up with a legal case. And I mean, and this is not how the Nas case came up with, obviously, but this is in terms of how one articulates one's own life experience, own experiences of friends and very, very close personal bonds through a legal language. So I think, just to add that, so I mean, during the process of the Nas Foundation case, we actually collected affidavits from people from around the country. One of the cases that Arvind was speaking about was of the two women who said they wanted to live together, whose parents objected. But we also had cases of people who were raised by hijras, people who had been um, picked up by police for just for acting a certain way, from by parents, and kind of the range of human experiences, both horrific and deeply touching, is something very moving about that. So putting all that together kind of enabled a certain confluence of the legal case, I think. So even the Nas Foundation case, which was based on a very much HIV/AIDS case, really did speak about the harassment of HIV/AIDS outreach workers, right? And there's something very compelling and very moving about how all those various stories come together under kind of a legal theory. So it's important that even though Navtej Johar was kind of the culmination, or one significant landmark in the struggle against for queer rights in India, it's the confluence of these various big and very small moments. So I think to find a starting point, as Arvind says, very difficult. There's so many, but I think it's important to acknowledge the fact that it's all of these stories put together that have come towards to making that moment.
Thank you. I want to, because you spoke of Nas, and I'll speak of it in some time. I'll start with speaking of Navtej first. It is said that the Indian Constitution didn't mark a break from the colonial rule, and it was almost a continuum of certain sense of the colonial, which was brought ahead in the post-colonial. And it was in instances, we can see it in instances of the Section 377, which was previously decriminalized, and sedition, which stands as it and even like grievous right now. Do you think that while Navtej judgment intended to undo a lot of colonial and post-colonial torture or violations, it does not exactly offer the kind of break that people saw it as in it was just a moment which did do some effect but did not actualize in the very sense of the social or the morality that it was trying to defy. So,
Yeah, that's sorry, Mayur, can I jump in?
Yeah, of course.
No, it's an important question, and many people have asked this. In fact, one of our colleagues made this point. I mean, it was some discussion we were having, and he called it a decorative judgment, right? And in another conference we attended in, I think, the courts in the Constitution in Hyderabad, where I think the vice chancellor over there made the point that it's a low hanging fruit. So there's a sense that it's not such a big deal. That's one kind of opinion. This what's the song and dance really about. So I thought we should look at this a little more closely and say, I mean, is it purely in our heads that, I mean, this marks an important landmark, or is there some evidence to say that it is an important landmark? And so the what I have found, at least, you look at the range of cases post Navtej which have been decided, all of which cite Navtej, and a lot of the cases uh, are in the high courts and reference broadly, most of them are about cases of two women or trans people, and trans people choose to run away because they want to be with each other. And when it comes before the court, the argument the couple invariably puts forward is saying Navtej recognizes my right to privacy and my right to autonomy and my right to dignity. And invariably, the High Court says this, we're bound by the decision of the Supreme Court in Navtej, and recognizes the rights of this women. Right? So when people say that it's not a transformative decision, I'm like, you all guys have got it wrong. It is a transformative decision based on the impact it's had on the lives of people around the country, just to the level of courtroom decision alone. There are many other dimensions one can speak about, but just the level of courtroom decision alone. And here I think, I was thinking about it, Mayur, maybe we can think about this. The contrast is actually, Shonali, the question you brought up, 124A, right? Kedarnath, like Navtej, is a case of reading down. But unlike Navtej, Kedarnath is a decision which, as you rightly indicated, the continuity is with the colonial interpretation. And Kedarnath has not become a part of a lived culture, a part of people's ways of thinking, a part of the rights of a community. It is not, right? And to me, the question is interesting. Why? Why both are reading down? Why is Navtej, I mean, if you accept my line of argument, why is Navtej so remarkably, such remarkable impact? at the ground level. In cases of women running away, in cases of discrimination, in case of the most recent case. Again, I think I just briefly cite this because I think it's worth spending some time on. It's not a decision; it's an order of the Chennai High Court, of the Madras High Court, and where the Justice Anand Venkatesh. And I read it and I was like, wow, I was so moved by that particular order. Because what the judge is saying, he's saying, I can give a judgment following Navtej, recognizing the rights of the, again, two women running away. That's the central thematic, really, in all these decisions. But he says, that I can do it. But it would really not do justice to what I'm thinking and I'm feeling. And it says for me to understand my own thoughts and to clarify my own thoughts on the question of LGBT people, I'm going to go to a counselor, a psychiatrist, and have a session with her. He documents all this in the order, and he goes to the session. And what is fascinating for me is the question he comes up, the question he asks the counselor, the psychiatrist. He says, "These two women, when they run away, are they running away because they want to have sex with each other? Is that it?" So in the course of the discussion, it comes across that people are more than the sex acts that they perform. There's a greater range of emotions, feelings, identities which are involved in being in love with each other. And then he finally comes to the conclusion that two women who are in love, the same as a man and a woman being in love, there's no difference really. And the way I understood that, it's taking forward the idea of apology in Navtej. When Justice Malhotra says history owes an apology to LGBT persons and their families for the ostracism that they've suffered, and Justice Chandrachud says civilization has been brutal, and what happened in the past should not happen again. This is Justice Anand Venkatesh taking forward that line of thinking. So to me, Navtej marks a definite break. It's a very important judgment, maybe more important in terms of the impact at the ground level than any other judgment we can think of in the history of the Supreme Court. I mean, maybe I'm overstating that case, but more than 124A. More than 124A, because Kedarnath lives in its is not implemented at the ground level. We know that. And I think question to me is why not? And perhaps one answer lies in the fact that Navtej is owned in a sense by a community. Navtej is part of wider popular discourse. People know Navtej. The judges may not get the order from may not read the Supreme Court judgment, but they know it because it's all around them. So maybe that's the reason why Navtej is particularly important judgment, not just because it's a judgment uh, by the court, but it's a judgment which people know is owned by a community, and a community which will say we will put pressure to ensure the judgment gets implemented and enforced.
Come in, yeah. So I think, yeah. So I think the question about colonial versus non-colonial is an important one, because for me, or my understanding, the idea that 377 was colonial was only one of a series of rhetorical arguments against 377, right? So to put it differently, I don't think the objection was that 377 was colonial. That was not the problem, because in that case the whole IPC would be a problem, right? So that wasn't our issue. In I think our issue, and it's the same issue with I know Arvind and I both on democratic broadly right, is the kind of impunity with which the state can operate, right? So that is the issue, and that kind of gets kind of labeled under the mark of colonial. And I think that was the main issue, right? So we're not so concerned about where the origins of law are. We're concerned about what a certain law enables the state or authorities of the state to do, and what effects that law has on the lives of ordinary people, right? So whether it's 124A or 377 or the UAPA, which is derived from colonial strategies of power, that is our objection. It's not so much of the fact that it's colonial, but the fact that it allows the state to operate with this vast amount of impunity, right? And I think just to come to Arvind's kind of question, or Arvind's statement of the fact that Navtej was low-hanging fruit, I think it's important to also, in addition to what Arvind said, to understand what enables something to be low-hanging fruit. It is not as if overnight the gay rights became like a very easy thing to do, even if it was easy. Let's say we accept that argument. It's not as if overnight LGBT rights became something that was very easy to do. It was a series of cases. It was Nas, the kind of the reaction to the overruling in Suresh Kumar Kaushal. It was the fact, as Arvind said, that Navtej was owned by a community, that Nas was owned by the community, right? And that these judgments have a popular discourse around them, that everyone can say Navtej, even though they haven't read it. It excites a certain imagination, and I think that's what's important over here. I mean, for me, the question of colonial versus non-colonial is a rhetorical argument, not quite a substantive one. Yeah, sorry. So I ended over there.
Yeah, I haven't like thought of it like that before, and it sort of makes sense also. Sort of makes it does make sense, and something that I just thought of when Arvind sir was answering about the recent Madras High Court judgment, where the judge went through therapy. Um, Otherwise, generally, the judges always they make judgment. I'm just making it through as I'm going. Just something I'm thinking through. That the Napte judgment, the judges disassociated themselves from the society. And in this Madras High Court judgment, the judge said, I am the society, where the idea of this judicial unconscious and how the judge is always impacted by the society was never really owned, neither in any terror trials, or neither in the Napte judgment also, even though they said that the community, we need to apologize on behalf of the community, or on behalf of the civilization. There was a certain distinction that they were trying to make, I think, between constitutional morality and social morality, also keeping themselves slightly away and above from social morality. In Madras High Court, judge intervention is also where they're assuming that they're the court is the judge is the society, and then they're also going through the entire process of therapy and becoming very vulnerable as probably society. So how do you see that? This was not planned, but this is something that just came to me right now.
I think you put it really beautifully, right? Where you're right. I mean, the power of Justice Venkatesh's judgment is that, right? He said, "I am the society," and that's something which is very, very rare for a judge to do. And I think again, you're completely right that Navtesh takes one step forward, but not enough in that particular dimension. But the judges, I think they don't think we are apologizing. They say history was an apology to LGBT persons and their families. Civilization has been brutal. All that is great, but I mean, what is your complicity in this entire story, and how are you going to address that complicity, and what are you going to do about it? Right? That's a point which they're a little silent about. Whereas here, I mean, for the judge, I mean, I thought, in fact, an apology and a judgment was I was like, wow, which judgment begins with an apology, or has an apology in it? I mean, in the Indian Supreme Court, I couldn't find anything else, And again, this is since there are many students here, maybe it's worth looking at, seeing are there any other spaces in the Indian history of the Indian Supreme Court where the court has begun or preferred an apology to a wounded, to an affected community. I thought that was fantastic. But then, as you rightly indicated, here this is several steps ahead. The judge says, "I am the society. I am complicit in this, and I am sorry. And what can I do about it?" That's the way he approaches it, right? So there's almost a, I think when you personalize it in that sense, there's a greater level of vulnerability which you're putting yourself in. Again, I mean, if you said that Navtej, the apology was unprecedented, I'm like, is this even more unprecedented? Can you think of a single judgment where the judge says, I'm going for counseling? And from this point of view, saying that I need to understand, right? And again, that's such a powerful way to think about it. Again, I was thinking of the U.S. Supreme Court, this Tubin's book, right, on Justice Blackmun. Again, why Blackmun enters the picture is he is the dissenting judge in Bowser's Hardwick, which is the case which upheld the constitutionality of the sodomy statute in Georgia. Just Blackmun gave a remarkable dissenting opinion where he really put forward the language of intimacy and privacy, which is what we have really developed on. So we owe him, in some senses, a debt of gratitude for beginning that journey, Justice Blackmun. But again, the story is, you go back to where Justice Blackmun came from. Tubin's point is, at that moment in time, the two judges who were appointed by the then conservative president, I don't remember who it was uh, the chief justice, who's Berger, and Blackman, and they were referred to at the time as what he calls the Minnesota twins, because they came from similar background, etc., etc. And they went on completely different journeys, right? We had Justice Berger, who was the embodiment of conservative way of thinking, and Justice Blackman, who became the most liberal judge on the court. And Tobin's point is, he learned on the bench by the cases which came before him. By hearing those cases, he learned and he became more liberal in understanding and his approach. But even that is not matched with Justice Venkatesh. He takes it one level beyond even that. So it's a quite a remarkable moment, actually, And I think it's again worth paying a lot more attention to and saying, is there any other such moment in the history of the judiciary itself? I mean, any part of the world, it would be a fantastic thing to pull out and look at that a little more closely. Thanks for asking the question. It's more, I think, conversation. I don't really have an answer.
Yeah. And I think the flip side of what Arvind is talking about is probably the judges in Suresh Kumar Kaushal, the Supreme Court judge in Suresh Kumar Kaushal. And this was an important point. So the basically said one of the judges, the senior judge on the bench, Suresh Kumar Kaushal, basically said something to the effect that I've never met a gay person, something like that, right? Or I don't know anyone who is. And I think his strategy or the reasoning or the reason why he said that was because almost to dismiss it as almost as like an elite concern, like only you urban rich people are actually homosexual, everyone else is getting along with their lives just fine, right? So I think that was where he was coming from. And I think and you really see that disdain, that kind of contempt, like in coming across through the Suresh Kumar Kaushal judgment. I think and I think the subjectivity of the judges was something that Shyam Devana, the lawyer for version 377, really understood that it really depends on the personality of judges, and a lot depends on the judge's kind of visceral, maybe not logical, legal reaction, but visceral reaction. So one of the things that we did during the 377 case was, apart from the personal narratives, provide examples from literature or history, right? So people who were so there's obviously Ruth Vanita's and Salim Kidwai's very important book, but also just, I mean, literature about LGBT people from around India. And that was one way in which we tried to kind of humanize the story, to think of, to tell the judges what LGBT lives look like in India, to kind of elicit some form of empathy. Obviously that failed, but that was the attempt, at least. So I think you can see kind of the flip of the polar opposite from the Madras High Court judge to the in the persona of the Supreme Court judges in Suresh Kumar Kaushal.
Yeah, I mean, that is why, because I have read Sushana Filman for one of my projects, and when I was reading the Madras High Court judgment, I could just connect it with Sushana Filman and the idea of that, and also Navtej, because in some sense Navtej also tries to amend only as much it can chew, and where she talks about that um, the idea or the speciality of the courts was such that in the trials of the Nazi and all of that, when she talks about Adolf Eichmann, etc. So she also talks about that how the court is trying to undo a lot which it can't, do. So for some reason, I don't know why, when I was reading Navtej, it seemed as if that Navtej was situated outside of the community or the idea of community, and which is how I see every court judgment, honestly. So something that I would like to ask you both actually is, if practiced outside a certain realm of normal, love appears to be inherently offensive to the social, as it assumed to disrupt the equilibrium. For instance, if it is intercaste, interreligious marriage, and you have, Arvind sir, written in your book that, and also like spoken elsewhere, that's same-sex love or intercaste or anything which is a love that crosses boundaries in terms of how it is supposed to be, um, is sort of an presents an aberration or presents like a disruption to the normal. And so, do you think that, as in, how do you understand love and law in that sense? Because I know that you've spoken about it a lot, but if you could just please reiterate. And do you think that the state fears transition? I also I also say this because there is an anti-conversion law, and then there is same-sex marriage. So when I just feel that whenever there is a transition, and the idea of transgender is also a sense of, I think it's a transition which I assume from whatever I've read. So how do you view this? First, the relation between love and law, and do you think that the state feels any idea of transition? Which is
Mayur, you want to go for it this time?
No, you're the expert in love and law. Go ahead.
Sure. No, I was just thinking, right? I think today's Pew survey report, which I think has come out, which has said that Indians are by and large tolerant of other religious communities, but they're very unaccepting of the issue of people who marry across lines of uh, religion. Religion. I think religion was the framework which was used. So I mean, it tells you how powerful is really this prohibition on love across boundaries of religion. And caste, it's just so shocking, right? That each literally, I mean, 2 days ago or 3 days ago, there's a case in Karnataka of a Dalit man who just merely messages another girl who he's interested in, and they have a bit of an exchange of messages for which all kinds of brutalities are inflicted on him, saying, "How dare he even message or establish a contact with any person who's outside his caste bracket, as it were." So the idea of what is unnatural love in the Indian context is very powerful and very closely linked to both caste and religion. And I think the UP, the love jihad law is an example really of that, you know. And again, you see the statute, it's just shocking that a law like that can even be enacted, right? You see the statute on the face of it. It says, what does it prohibit? It prohibits conversion by fraud, conversion um, by undue influence. Undue influence is a debatable term, and conversion by the other term is marriage, right? If you say fraud and marriage, I mean, what is the comparison between both? I think within the more radical framework case, fraud and marriage, we can take that line. But within the framework of the law, I mean, fraud and marriage should not be in the same statute at all, you know. So it only bespeaks this kind of literally this way of targeting, this idea of crossing, as you rightly put it, these boundaries of religion and caste, which are very set as far as the Indian broader Indian social framework is. And I think what our effort, I think why we were very keen on the idea of the right to love as a part of what Navtej is articulating, and why we wanted that point, why we wanted very importantly there is, I mean, people have also argued that, you know, right to love. Why do you need a right to love? Right? You have a right to autonomy. Autonomy is a broader framework. It includes within your right to love. So what do you mean by right to love? Why do you need it at all? Right? The reason why we were keen on it is because right to love speaks of this one dimension of the queer struggle. The dimension which says that we have to challenge not just the norms of gender and sexuality, but all the range of oppressions which confine the autonomy of the human being to express his intimacy with another person, right? His or her intimacy with another person. And why this is important again is we can articulate the struggle of the queer community as a struggle of LGBTI people, right? For the equal, as you said, marriage, for the right to marriage, for the right to equality, for the right to non-discrimination. That's a valid, very important, absolutely fundamental, right? Which we're still struggling for. But the idea of queer comes in when you say that you also want to challenge the norms of gender and sexuality and the norms in caste and religion, which set in place a certain confinement which doesn't allow for human beings to express themselves with the right to autonomy and the right to expression. So, really, when we say right to love as a part of the struggle of the queer community, we're saying, as Justice Chandrachud puts it in Avtej, right to love is not just a battle for the LGBT community, it's a battle for all of us. If you see the love jihad law, if you see the range of Dalit men who've been killed for daring to fall in uh, love with Brahmin women, upper caste women, then you'll see why the right to love is a battle for really all of us. And I think the point really is this, right? I mean, again, one last point I'll make on this is what is your objective? If you look at it from a constitutional perspective, liberty is a part of it, equality is a part of it, and the third dimension is fraternity, right? And again, fraternity, go back to the history in the Constituent Assembly debates. Fraternity is there in the Indian Constitution because Dr. Ambedkar wanted it to be there. Why did he want it to be there? Because he felt the fraternity is an important way in which you begin to challenge these norms of separate and unequal, which are very much part of Indian society. It's not the only strategy, but it's one strategy to displace this norm is through the idea of the right to love. You say that, we're going to cut through these barriers of religion and caste and gender and sexuality and establish a different way of relating to each other, which is based on the notion of equality and liberty.
I can't compete with Arvind on right to love. He's the expert, but I just wanted to kind of highlight one of the things tonight that you mentioned, which I think was quite an interesting thing to say that at the same time where you have like a marriage equality case going on in the Delhi High Court, you also have uh, the love jihad laws being enacted or in place in various states. And I think it's quite an astounding thing if you think about it, right? The fact that that LGBT people are arguing the same for marriage, for the right to marry, when that same right is being taken away from interreligious couples, or more particularly because the law is targeted towards against Muslims who wish to marry outside the community, right? And so I think at one level it's this massive like contradiction. You think that it's two distinct, but if you look at, I guess if you think about it shows several things. First of all, I think for one is that this idea of marriage is not something. I mean, there's the radical critique, right, of marriage, which is we can keep that kind of as in the background a bit, but also in terms of what kind of the organic linkages between the LGBT community's idea of being in love and being together with regard to intercaste and religious marriage, right? So no one is claiming that for interreligious marriage or intercaste marriage that's somehow kind of a betrayal of one's ethical norms, right? A betrayal of queer ethics in a sense. And so I think so in one sense it shows that there is something about marriage that is important to communities, LGBT communities and religious and caste communities, right? And I guess the other kind of commonality which we can see is the response of the state to both, right? So the response of the state in the Delhi High Court, I can't quote from right now, but one was actually quite deeply offensive in a certain way, right? And the fact that you have the state governments pushing for love jihad laws is also deeply offensive. It's clearly bigotry towards one particular community, just as the response of the Union government in the Delhi High Court is bigotry towards the LGBT community. So I think there are various commonalities, just despite the fact that it's just difficult to wrap one's head around the fact that you have love jihad and gay marriage happening at the same time.
I had like a different question to follow up, but now that we're talking about marriage, I think it's only in the same vein. That do you think that decriminalizing hence was easier, as in Section 7377 was easier than recognizing same-sex marriage because the latter is innately attached to the idea of custom and religion and social morality. And also, since I don't know, I can't like miss it, but there is also this role of the state being the political state also being very religious in terms of its understanding. And it also makes together, as in religion and state together, make this is social in at least India. And so, in that context, how do you see that? Why? Because recently the Delhi High Court also said, when the state responded when Delhi High Court was listening to a plea regarding this marriage, same-sex marriage, they say that people are not dying if you can't get married. This is not something that you have to listen to it right now. Mukul Rohatgi, I think, was presenting the state, and that is what they said. So, do you think that the court is also somewhere conscious of taking it up because it deals with a lot of things? Like, it deals with custom, it deals with personal laws, it deals with religion as is. So, I mean,
I haven't followed the case in particular. So it would be interesting to get in the particulars of the case. Arvind, if you probably know better in terms of what exactly the prayer is. Sorry, go on.
No, I just the maybe the only point to add is Shonali referred to the affidavit of the central government, and the affidavit of the central government is really very. To me, I read it and I said, "Wow!" It reminds me of 2004. It was like the affidavit of the central government before the Delhi High Court, or on the 377 case. The same kind of a almost a massive resistance, saying that there's no question, absolutely no question of marriage, because that question doesn't arise at all. The way the central government affidavit was structured. The prayer, I think that the three prayers, what my understanding, one is in terms of the Special Marriage Act, that is the expansion or reinterpretation of the word bride and bridegroom in a gender neutral fashion, and similarly with the Hindu Marriage Act as well, and the Registration of Foreign Marriage Act as well. That's the other petition which the same prayer is being asked for. And initially, it's interesting that when the Justice Enlaw was hearing the matter, he made the point, this is not an adversarial petition, to the central government. We need to see how we can accommodate this grouping. I give you some time, come back to me, and tell me how you accommodate this grouping. Right? And there are precedents to this. Precedent, of course, in terms of, um, the Chennai High Court, Justice Swaminathan's judgment, where he sees the word, it's a more minor one, but anyway, he sees the word bride in the Hindu Marriage Act as including transgender women. So there's a certain expansion he's allowed for. So I guess Justice Enlaw's opinion is, in some ways, can you use that and can you expand a little bit more? But the central government came down like a ton of bricks. They said, no question, this law cannot be touched. Be it the Hindu Marriage Act, Special Marriage Act, or the Registration of Foreign Marriages Act. So that seems to be the position of the of the central government, and they've obviously taken the case that this touches something very fundamental, and we can't give into this. No, we can't give into this. That's the line they're taking. Again, the question, of course, for us is, that's the line. Again, if you in 2004, the line of the central government is there are no gays and lesbians in India. That was the line. And the criminal law cannot run separate from society. That was the line they took in 2004. And it's a very similar line which they're taking now. Complete hostility, complete denial, and saying we will not give you an inch. As far as this is concerned. So they've set it up as a fight. That's very, very clear. Where this goes is a question. I don't know where all of this goes. Because uh, I guess there are all kinds of questions which one has really. Um if you're touching on something which is very, very fundamental as far as the religious communities are concerned and their own perception of it, right? Then will this go down the line of maybe the same kind of hostility which we see in terms of interreligious, intercaste, right? With that same kind of hostility which is not there now become a part of the framework? And there's some initial signs, right, that you see that where, for example, in courts with in two women running away, you see a certain kind of public pressure building up on that, saying that we can't tolerate this or we can't accept this. There's a sense of that happening. We don't know to what extent the right wing will coalesce around these issues as well. So if that happens, then of course there's one direction it can go in. The other direction it can go in, again, in a completely, I don't know, I don't think it'll go in, but it can go in, is where the government, after a period of time, like they did like they did in Navtej, tells the court that we stand educated, we're open to this possibility. how can we, and open to the possibility of reinterpreting the particular law, conceding the constitutionality of same-sex marriage, or open to the reinterpretation of these particular statutes. That's another direction it can go in. I don't see that happening again, but this again, it's an opinion, so I don't really know. It's just a speculative opinion.
So I'll come back to the question I was asking earlier. In this is for Dr. Suresh also to answer. I mean, for him to answer basically more, and then Arvind sir can take on. In your work, The Terrorist Lives in Delhi, Delhi's court, you go through several legal documents and you talk about material technicalities and how those also, while they're also marginalizing in one sense, they are also they open access for people. And I'm sorry for if like the interpretation is very dumb, I'm sorry, but you talk about forming solidarities and through those material technicalities, and you talk about that how those interactions emerge from those reading the legal document or just going through the police file or just going through the panchnama, etc., all of that. So do you, as in from this experience of the activism that began way before, when maybe the affidavits that you had filed as ALF and the affidavit the lawyer collectives had filed, um, do you think that the course in the course of activism there was also this solidarity that came through reading the judgment and through like fighting and negotiation with the court and with the state? Do you think that is also like a, like I don't know why I sort of found it very similar. So are there any anecdotes that you have probably from that sense of that sort of compare or are in the same vein?
Yeah, I think there is. I mean, just the process. Thank you for giving a plug for my article. I appreciate it. No, I think it is because the process of just putting together those affidavits was something that was across the country, right? So it brings you in touch. Obviously, you kind of have you have existing networks, but what it forces you to do or enables you to do is to reach people that you haven't reached before, right? For example, parents of LGBT people, for people who I've never met before, psychiatrists, teachers, all coming together in a kind of a broader framework, right? So it really, and I kind of think back to the early days of the petition when we in 2000, in the early 2000s, and I think the effect the ambition was a bit more modest at that point of time, right? We wanted to build community around this, right, as a way of mobilizing community, and it really did that, because if you look at the reaction to Suresh Kumar Kaushal, you see what that mobilization enabled, right? So it not only brought people together, or me together in contact with other people, also different lawyers, different activists, but it also forced the conversation into newspapers, into TV programs, into radio shows, right? So into Bollywood almost. So in a sense, this kind of building momentum through these small acts of just putting together affidavits, or having workshops, or having kind of community outreach programs, I think is an important thing towards building community. And it goes back to the earlier conversation having on kind of the origin of the case. It's these kind of smaller confluences, smaller streams that build into, I think, this bigger story of the LGBT movement in India.
Oh, if you have something to add, please go ahead. If you have something to add.
Yeah, no, I'm just thinking because Mayur's covered it quite well, So in terms of I think I was thinking as he was speaking that's true, I mean, how, and the idea initially, in fact, I've said this many times in 2004, 5, 1, 2, 3, whichever year, you had asked us, when will 377 go? And I said, not in my lifetime, right? Not in my lifetime. I mean, I was very clear on that. And it's very clear. We were doing this to build a sense of community and to get people together, and to really that was the objective. And we had no we it was not on the top of my mind that the law would go, which is why the process was absolutely vital for us. It was absolutely vital that you have discussions around the law. It was absolutely vital that law schools discuss it. It was absolutely vital that within the queer community we begin to have discussions around this particular law. That was really the objective, uh, the way we saw it. And obviously, it's interesting, right? I mean, once it begins in that way, uh, it takes on its own momentum. And before you realize it, you realize that it has a certain kind of a public profile. And I realized this because wherever you went, right? I mean, once I remember the activist from Tamil Nadu, who each time he'd come and meet me, say, sir, what's happening on the case? What's happening on the case? And I was like, wow, here is this guy sitting in Chennai, and part of a community-based organization. He's passionately following this case. This other guy from Odisha who's very isolated, very alone, and he used to get in touch regularly. And his only question is what's happening on the case. A range of people would call up and say what's happening on the case. They all want to know what the developments were, because for them it gave them that sense of hope somewhere that something will change. It where there's no community, they made a connection with an invisible community, and in places it allowed for the development of a sense of community. So it did all of these things, which the case did. And in a sense, even if you think about how this issue emerged within an activist context, it emerged because of the 377 linkage, or the battle against this particular colonial law. How do you, even within a activist setting, how do you speak about LGBT rights? I mean, will you go around telling your colleagues who are fighting the anti-terror cases that you're fighting for your right to love somebody of your own sex? They'll be like, brother, get a life. I mean, the more important things going on. What is this love we're going on about? But you put it in terms of, say, 377. The law which criminalizes the right to dignity, the right to equality, right to expression. People understand that. People get that. They see the link between that 124 range or the colonial laws. So the building an activist community, 377 was the only way it happened. And we know that, right? I mean, before this, the cases of women who were running away, women who were in distress. It became our lesbian colleagues and comrades found it very difficult to make any progress on that matter, because it was seen as a personal private issue, and that's the way it was seen, right? Moment it became this question of the law, people somehow got in the activist community understood it. People in a larger sense understood it. And I remember this one particular line from, I think, one of these newspapers at a point in time. And very soon, 377 became a symbol of all that was wrong with the sexual universe. Right? So all the people who were dissatisfied with the sexual universe, the normative sexual universe, said, this is something on which we are happy to hang our battle, as it were. So it became a symbol, and it really served to mobilize really a range of communities who were dissatisfied in the broader sense with the heteronormative framework itself. And this is important because we never saw 377 as a battle to remove a provision in the Indian Penal Code, which again is maybe the contrast with Kedarnath. It is a broader battle to really challenge the notion of heteronormativity, to make space for a diversity of ways of living and loving, in the broadest possible sense. I think that's all what the campaign enabled.
Thank you for that. Something that I was interesting to also know is, since you were like firsthand involved in the NAS Foundation judgment, and the decriminalization that happened the first time in terms of the judgment and how it happened, and the decriminalization that happened the second time. Is there any like a particular part of the judgment, or particular I don't know, aspect of the judgment that you think changed from NAS to Naptej?
So again, Mayur, shall I go ahead? Okay, okay. So, sorry, I just happily jumped in without yeah. No, it's a good question. And if you'd asked me again, when at one point in time, I told you my opinion was this law is not going to go. So 377, the judgment came. I was like, what an incredible judgment. I mean, in terms of the idea of the way they've articulated dignity, the way they've expansive notion of privacy, the way they articulated the right to equality, and the way they located it within the framework of the Constitution in terms of the idea of inclusivity and the idea of constitutional morality. So, I mean, if you ask me, I would have said, you can't do plus on this. You can't do a NAS plus. It's not possible to beat this judgment. It's like, whatever will be done, you can only at best affirm this judgment. But then I felt Navtesh took it several steps forward, actually, which is why I think it's a really remarkable judgment done in the context where you felt there's nothing more which could be done. I mean, I thought there's nothing more which could be done. They came up with several new points. Uh, One is, of course, the idea of the apology we already spoken about. That's a completely, that's not there in the NAS context, and that's there in Navtesh. And we've seen the productivity of that when we've seen Justice Arvind Venkatesh take forward the idea of apology in the judgment. Second is it's there, but it's a more fully developed notion of the idea of equality and non-discrimination, where they've made the strong point that the problem with 377 is not just in terms of the prohibition of the acts that it prohibits, but also the problem with it being based on certain kind of stereotypes of what is unnatural and what is natural. And the point which Justice Chandrachud makes is these stereotypes don't just live in the text, but they go from the text and impact real people's lives. So if a transgender person is going to try to get a passport done, and the police deal with her like a thief, that thinking comes from the law. That stereotype that trans people are thieves comes from the law. And that concept again is very very strongly there, and it's this idea of stereotypes as a violation of right to non-discrimination. It's developed in Navtej. It's taken forward in the adultery judgment, Joseph Shine, as well as in Sabrimala. So that's a very important kind of a development, which Navtej is the beginning points of. So that's again a significant difference between. Okay, I wouldn't say significant difference. Anuj Garg has it in NAS as well. It's developed. Let's say it's developed in Navtej. And there's one more point which I had, which we've spoken about, is the particular articulation of the right to love. As a as which is there in Navtej. Again, that's very important from the point of view of a political campaign. Saying that that this is a right which is integral to the LGBT community, and we want to take it forward for all of Indian society. And that's the third point. Constitutional morality is there in both judgments. Expansive notion of privacy, there in both judgments. Dignity as being violated by 377, there in both judgments. So I think nothing builds on us, but it definitely builds on us. That's why it's an important judgment.
I would just add, thank you, Arvind, again. I know. I think I'm still kind of tied to the final page of the Nas Foundation judgment in the Delhi High Court, where he talks about constitutionality, and also the fact that he read it when we were there, I think, is something that's stuck indelibly in my mind. Kind of where he talks about constitutionality, the ability of people to love one another. I think it's something very moving about that. I think also one of the important things is to think about, as kind of what's implicit in your question, Sonali, is to think about what lies in the future. What kind of future movement does something hold, right? So when you say developments, you're always thinking about what could be next. What is the potential of something to be different in the future, right? And I think that is something that's important, right? So to think of where we can take ideas of fraternity, where we can take ideas of privacy and dignity to the future, what kind of future growth is something that is something that the queer move is obviously based on what the idea of precedent is, but also it's just that based on kind of what notions of what ideas of hope can we have in the future, even at such dark times. And I think it's important to hold that it is possible to have an expansion of ideas that are fundamental to kind of liberty and constitutionalism.
I'll just ask one question that came in the chat. It says after the decriminalization of Section 377, a huge part of the society is not in favor of the decision and treating same sex couples in a very strange manner, which is disheartening to see. My question is how and in what ways we can change the society's perspective or views towards the concern and their weird behavior. Some people are too rigid with their views and even didn't want to understand the reasoning or logics behind the issues. This is Rupal Yadav has asked.
Yeah, I think in some ways the process of change is something we don't obviously fully understand. It's something you can't fully predict either. The range of factors which result in a certain kind of a change, a certain kind of a transformation. And I think the point which we've been trying to make is NAS began by giving us a new language. And that's very important because we can think about it. How do you speak about sex and sexuality in the context of India, right? And I think I remember at some point in time, even Justice Shah making the point in the Delhi High Court of how he was speaking to the government council and saying that you know the ways we speak about these issues, right? We speak about it in sneers, we speak about it in whispers, we speak about it at the coffee break or the cigarette break. We speak in that kind of slightly sneering tone about LGBT people, right? And so he understood that that's the place where transformation really needs to happen. And he's provided a certain angle for the transformation by saying that, we understand the, the sexual choices people make is really part of the right to dignity, right? And when we think of dignity as really the other of humiliation, right? And we all know what humiliation can mean. Humiliation is when you feel less than human, you feel degraded in some fashion. And sexuality is often a locus for that feeling of humiliation and degradation. And here you have a judgment which saying that the choice you make is not something which should be the subject of this kind of a scorn or a scorn from society, but it's a part of your intimate life. It's a part of your right to dignity. So that's a very powerful language given to us by the judgment itself. And of course, Navtesh takes that forward as well. So we have a certain way to speak about sex and sexuality, and that's a great, I think, great on LGBT lives, and that's really a great starting point. And of course, from there, I mean, you can think of how different authority figures, in some ways, movements, and can take this forward as well. And just Anand Venkatesh is the other fantastic example. I mean, I was thinking, what is the value of the judgment? People, I mean, you look at it technically, you can argue that it's an order, and he's passed a series of orders which may not impact the world at large. But I'm like, he's a man of a different generation, and the people who he's a figure of authority, he will listen to in certain circles. And the fact that he's saying this will transform the worlds within which he lives. Give you one more example. I mean, that's within the sphere of law, which is what we've spoken about, and how transformation can happen within the sphere of law itself. um, our friend in Karnataka, a Kannada author called Vasudendra, wrote the first Kannada novel based on a gay theme. And again, I mean, he was telling me that who is his audience? His audience is middle class women from a very conservative locality in Bangalore called Malleshwaram. That's his audience, right? And suddenly you have this book which is speaking about same-sex love, and they're forced to read it, right? And they love this guy because he writes beautifully, and they love his novels. And suddenly they have this particular novel which is speaking about a theme which they've never thought about before. And that's forcing them to think about this and to say, hey, how do we reconcile this? So change happens through that process as well. And I think popular culture and films might be another area I'm not competent to speak about, but I'm saying change happens through that area as well. And of course, change happens through the fact that you establish a sense of community. And once you establish a sense of community, and there's a collective, and the collective is able to take issues forward and challenge these structures of broadly put heteronormativity in different spheres, as it were. Change can even, to our colleague who's asking the question, wherever you are, right, in whatever small ways, if you get together two or three other people and begin talking about these issues, and start challenging the norms in your own small private circles, you'll realize how change, before you know it, change kind of catches fire.
Yeah, I don't think Arvind always has the best words, but no, I think one of two things that Arvind kind of mentioned there, I think is one is as for Rupal, who asked the question, is to find community. I think that's really important, to find people. They don't have to be, I'm making assumptions about your sexuality, but they can be gay or straight or queer or trans or whatever. But it's important to find community that who you can speak to, kind of think about language, think about who, think or just to have fun, also. But it's also important to keep speaking about it, right? And as Arvind said, just speaking about it doesn't indicate that things could get better. We never know in which direction change will go, but it's important, even if it goes badly, to keep speaking about it. I think to build up a community to kind of give you the kind of the strength in order to speak, which is effectively what the LGBT community did with the cases. It built up a community to give us the language with to speak. So I think it's a process of maybe translating that into kind of our own lives, to see how we can build a community that will give us a language in our conversations to speak and to challenge those who may not agree with us.
Thank you. Thank you for saying that. I was reading Law Like Love again. And if anybody hasn't read that book, please do. And so that you can get confused and can't understand certain things and be like, why am I so dumb? But that's like the feeling I got after reading a few chapters. And one of them was Dr. Suresh, your chapter. I could not understand for the world of it what it meant. I'm just trying to position a question from that chapter, and please forgive me again because it's very complex for my understanding. Um, we often use the terms such as coming out or owning yourself, which is what you're also talking about, and or owning your identity. In one of your essays in the book, you draw a link between identity and property. And you present that arguing one's identity confers public power to other parties. So can you explain it? And because I thought that this is something that should be spoken about, because it was such an interesting idea where you talk about Ilyas and Kamla and all of that. So that, can you please like explain for someone like me, because you are also imagining property there, and you're talking about identity, and then you're drawing an inference, and you're also probably saying that uh, your identity can't be of your own. This is what I've understood. But and it's in challenging it or in arguing it for it, it also becomes public because the public poses a threat to. So this is what I've understood. But if you could like explain the case and then
So first of all, apologies, Sonali, for inflicting that article on you. It was written in a different avatar and different genre, I think. So the kind of the cases that I was looking at are two cases from Madhya Pradesh, which are about the relationship between Hijra identity and the ability to own property, right? So in another book, I forget who the author is, on hijras in Hyderabad, she basically talks about how we kind of look at hijras always through the lens of gender, right? Or look at LGBT only through the lens of sexuality, right? Or LGB through the lens of sexuality. I think this is so what her basic argument is to think about the different lives or the rich kind of lives that people live outside of their gender, that's not immediately colonized by ideas of gender identity or sexual identities, right? And so I think so the cases that I was looking at was the relationship between hijra identity and property, and looking at how people can inherit property. So there are two cases. One was about whether a hijra can inherit property, or in what law does the hijra follow. And the other one was a property case, where was an election case where the person who was a hijra stood as on a reserve constituency for women. So the question is, was she a woman, or was she a woman, or was she a transgender person? Was a hijra, right? So the idea, I think, in a broad nutshell, is just thinking about how one's own identity is is always constituted in relation to someone else. That is true. Like, for example, you say I'm gay, I'm straight, I'm bi, I'm trans, whatever. I'm gender non-conforming, I'm gender conforming. There's all ways in which identity plays off one another. But also, so in a sense, even though once one owns oneself, one owns identity, one's always kind of shifting narratives of one's own identity in relation to other people, right? And I was looking at how property is implicated in that, and how even the idea of property, it says, I own this phone, is not actually I own this phone. I own this phone with respect to you, right? You cannot take the physical object from me, um, but I don't own the copyright on or the patents on any of the technology in the phone, right? So it's kind of looking at in a very roundabout, theoretical, and probably not articulate way, of the linkages between identity and property, and what discourse of property can tell us about how we understand our own identities.
Thank you. I mean, that was really, it was, I think, one of the most like interesting arguments that got me thinking about, I think, because you
I'm
talk
glad.
property and subjectivities of and how that forms. Um, okay, so I wanted to ask something from Arvind sir also and you also. I'll post the question first to him that among the many elements that was there in the Naptage judgment, there was the idea of dignity. And we have a book club called Law Octopus Law School Book Club. So we read Sex and the Supreme Court there. And one of the pieces, like one of the essays is by Justice A.K. Sekri, who's also talking about how human rights are based on the concept of dignity. And then he's like bringing in the philosophical perspective, Kant and moral and morality, and how it is the dignity is like is a normative concept which is attached to the idea of how human rights as it is. And so how do you understand dignity with respect to sexuality as is, and also how do you locate it within the judgment? Because one, and I'll like follow up with another question which like pops from reading Justice Sikri, where he says that the person who is under trial is also dignified. And I'm going to sort of break away from the idea of sexuality into the idea of gendered idea of state. So first, like the question from you is, Anvin sir, how do you look at dignity and love and sexuality? And why is it important to link it back to dignity and not privacy? Because you spoke about that love is social, and also dignity in Naftage judgment.
The See, one point would be that, I mean, the starting point would be that I don't see privacy and dignity as, as not related to each other. And again, of course, I mean, the most articulate exposition of this is the privacy judgment, where, I mean, again, you read Justice Chandrachud's opinion. It's a very powerful actually statement from even from the definitely from the LGBT queer perspective, because what he is indicating is that what is privacy? He's saying it's that space you have where you can develop either the person you are, the literature you want to read, the books you want to pursue, etc. Uh, Apart from what the gaze of society is. That is, if you want to develop as an individual, right, who might be in opposition to the norms of your society, then privacy is absolutely integral. And you think of it in terms of this person who wants to write a book which is completely challenging the norms of uh, the family he comes from or she comes from, right? You need that what Virginia Woolf famously called room of one's own, right? Where you don't have that person looking over your shoulder telling you how to live your life, and that's absolutely integral. That's the dimension of privacy, which is integral to queer lives. Again, we know this because the family is the predominant institution through which of normativity, of reproducing the norms of heterosexuality, as it were. So it's in that context that privacy as articulating, as putting forward not the zonal notion, but the idea of your right to control decisions about your intimate life, about your personal life, but who you choose to be in love with, who you choose to be with, who you choose to have a sexual relationship with. All of that comes under this idea of privacy. Again, as articulated in Nas page, and famously the privacy judgment as well. How does that link to the notion of dignity? Is your question. What is dignity? Again, dignity is not an easy question to really answer. There's a very interesting book, I think, I think Gopal Guru has a very nice article on dignity, where he makes the point that, to make the point that dignity is a nonsensical notion doesn't make sense from the perspective of people who've been denied dignity their whole lives. And from Dalit perspective, dignity is absolutely vital and absolutely central kind of a framework within which one understands the kinds of violations one suffer. Again, you go back to Ambedkar, right? His articulation is that he said, see, sometimes food is not the most important thing. He said a violation of dignity, this really gets to you. It's a violation of the human spirit in a way which you find it very difficult to tolerate. Again, you can imagine from a caste perspective what dignity is. If you read any, in today's context, if you read any form of Dalit literature, Dalit autobiography, or you get a sense, right, of that sense of humiliation which people face because of who they are. You go to a particular hotel, and then people know the caste you come from, and then they say, no, you can't sit here, you can't drink from here. That's the sense of humiliation. Again, you go back to Ambedkar's work in terms of waiting for a visa, right? He articulates that. You get that sense of of dignity, because he's saying that when I went to school, I was forced to sit on a separate gunny sack which I had to take back with me. And then he says, if I want to drink water, uh, it really depended upon the vagaries of the peon who was in charge of that particular water tap. If he was there and if he was in a good mood, he'd open the tap. If he wasn't, and I'd take the water from below. If he wasn't, I had no water for the day. And that again captures a sense of what dignity does to you, how it makes you less than human, how it puts you in that particular corner, makes you feel not lowers a sense of self and sense of self-esteem. Coming to the Constitution, to me, what I found very again, if you there's a listen legal audience, I'd suggest that you read this book by Akash Singh Rathore called Ambedkar's Constitution. It makes a couple of very important points, but the one very important and interesting point made, which I didn't know actually till I read the book, and I was like, wow. I wonder how many people don't know this point. That if you look at the objectives resolution and look at the preamble, some of the concepts missing from the objectives resolution, which are there in the preamble, one is fraternity, is there because Ambedkar wanted it to be there, and the other is dignity. And again, the point which Akash Singh, the fraternity we have textual evidence for, but the point which Akash Singh Rathore makes is dignity also enters the Indian constitution because of Ambedkar's intervention. And the point he makes is this, right? The where we get textual evidence for this is in the debate on the phrasing, right? It says fraternity assuring the dignity of the individual and the unity of the nation. Somebody proposes an amendment, said that let's reverse the order. Let it be unity of the nation and dignity of the individual. Ambedkar puts his foot down and says no. It will be dignity of the individual, assuring the dignity of the individual and the unity of the nation. He says it's not just a lexical priority, it's a philosophical priority, because the idea is you can't have a united nation unless you protect the dignity of the individual. That's the core of the entire framework. So it's a lexical priority, it's a philosophical priority. It's the idea of the Indian Constitution is you premise it on the issue that dignity is inviolable. And that's Ambedkar's contribution, again coming to that question. So from that, if you expand the notion of dignity, then dignity is to do with the question of choice about your intimate life. That's one dimension on which Nas goes, right? If you want to put it in very, very specific kind of a term, that's the aspect of dignity which Nas captures.
Thank you. Thank you. Thanks a lot for that. I have like two questions left, but I have others also, but I'll just ask like the last two questions. And something that I wanted to connect is because Dr. Suresh, her work is about terrorist, as in the anti-terror laws segment of the, and there also you're dealing with something that, so I'm just trying to make sense of this as we go. So please forgive me if it doesn't make sense in some sense. Sorry. But I just wanted to ask that the state is always like threatened by a terrorist, or it assumes that it is threatened by a certain kind of identity which is of some religion, which could like attack it. And going back to the before the time of decriminalization, it was something similar, I'm assuming, for people from different sexualities, especially the third gender. Where, and what I've understood is also that the sexuality was something that the state is also threatened of anyway, because of how it treats sex work and how the Immoral Trafficking Act or the Transgenders Act in the recent past. So all of that is what I've understood it, that the state is almost threatened of. Were you like in when researching, or since you work on both these, have worked on both these things, were you like able to draw a connection between those identities in themselves, as something that is prescribed by law as an identity, or something that comes under the purview of criminalization anyway, just by the way of existing, which happens in both these cases? So do you like before decriminalization and also in some sense after, because sex work is also something that we deal with the idea of marginalization of, or the idea of the hidden, and also like has a lot of ambiguities in the language, similarly, which is the case with UAPA or Arms Act or other acts similar, which like TADA or POTA after that, and now UAPA. So do you like contrast or make like similarities between the two identities?
So that's a good question. Thank you for that, Sonali. So just kind of to put the factual terrain out there, most anti-terror cases don't involve bombs and guns. They usually involve, I have no statistical evidence for this, but it's purely anecdotal, involve acts of membership or acts of speech, right? Or they've done something that shows that they are members, or they would alleged to have like sent money back to Kashmir or sent a phone somewhere, stuff like that can impacts on what membership is. So when you think about terrorism, it isn't big acts of violence, but smaller acts at the state that the police, for whatever reason, has decided to pursue under terrorism charges, right? Um, so before I go to the serious, a funny anecdote. In the one of my favorite counter affidavits in the Suresh Kumar Kaushal case, I think it was basically made the counter affidavit basically of one of the people who wanted to support Section 377. Basically said that if Section 377 comes in, then all the soldiers on the border will be having sex with each other, and no one can defend us from Pakistan, right? And I'm putting it crudely, well, slightly more crudely than the counter affidavit put it. But you can also see this idea of threat to society, not just through this very funny counter affidavit, but also through the 2004 counter affidavit filed by the Union Ministry, which basically Union Home Ministry basically said that will open the floodgates of delinquent behavior. So almost as if society itself will collapse if people were allowed to, be gay in public, right? So there's this, in both senses, there's this kind of existential threat to, or the argument at least, I'm not sure if they actually feel it, but the argument at least is that there's an existential threat to the society. But for me, what connects both kind of the anti-terror and the 377 is a lot to do with police impunity, or what the law allows for, right? So with Section 377, we know that very few cases are actually registered. Very few FIRs are actually registered. What it allowed the police and general member of the public to do was to harass, rape, extort, blackmail, right? And that was the main issue, right? That's the way impunity operates, Section 377. For anti-terror, it's, even though it's quite on paper in terms of actual cases filed, but there's great impunity with it, right? So even the big anti-terror cases, Parliament attack case being kind of the supposed justification for anti-terror law, didn't actually invoke the anti-terror law. In the Supreme Court didn't actually rely upon that when it finally issued some of the convictions, right? So the idea that you need an anti-terror law to combat terrorism, I think, is a false one. All it allows the police to do is to detain people for longer than necessary. They use it almost as if it's a preventive detention law than it is a criminal statute. The fact that it's virtually impossible to get bail under an anti-terror law means that you spend years and years and years of your life in jail waiting for a time when you'll be acquitted. Some of the people who I know have been through jail for 14 years on the flimsiest of evidence and were finally acquitted, right? So if you just to link it back to kind of the previous discussion on dignity, this inhumanity, right, of the legal system, of that the UAPA and other emergency legislations kind of enact, is an act of pure humiliation, right? How do you go on with your life after you've been through 14 years of a trial where you're ultimately acquitted, right? And everyone knows that the evidence is flimsy. The police will also tell you they know the evidence is flimsy. But the fact that the UAP allows you to detain people for such a long period of time is just mind-boggling. It's infuriating almost. And so for me, what's connected both of these things, apart from me being homosexual, is the fact that it's the grave inhumanity of these two kind of legal systems.
Thank you for that. And just I'll just free you in like 5 minutes max if you have time. Um, I just wanted to ask that how important is in terms of just going back to the idea of queer, and I wanted to understand what you understand of queer now, because your book also like begins with the idea of what is the meaning of queer and how it is interpreted, and how it's not just about sexuality. And why these terms LGBTQI plus, and there's a lot of debate that this is not how you should, this is not where I belong, this is where I belong. I don't believe in binaries. Why is it, why is the language of sexuality so important, or love? So if you can, like, this is something I wanted to understand.
Can I go ahead, Arvind? Yeah. So I think for me, so it's not a question that can be resolved in a certain sense, right? So first, one of my friends jokingly called himself post gay pre queer, right? Kind of to show that just as a kind of play on language, right? He didn't seriously ascribe to that identity. Maybe I'm wrong. Anyways, but I think it's not a question that has a conclusion, simply because who we are is always in flux, right? May not be individually, but how communities identify always in flux. And in certain sense, finding that languages will also be always in flux, right? So, I mean, for me personally, there's a certain tendency, I think, in some strands of the theoretical strand to say, okay, this is queer, this is not queer. Or that's LGBT, that's a queer perspective, that's not a queer perspective, and for me that's kind of reductive, because it denies kind of the way in which all our identities move, and how language itself can move. I mean, I see the value in queer theory in terms of destabilizing gender norms and deselling anything normative. But I think what's important for me, or what's interesting for me, is the way in which language can accommodate or can move, or we can create new languages in order to articulate what our lives are, who we are, what we are feeling. And so that movement's important, I think, for me to think about what range of possibility is there in life and in language.
Yeah, no, I that's well put. I quite agree with the way Mayur has put it. And no, the idea that, it would be stupid or foolish of us to put any kind of resolution saying this is the identity framework one should work with or not with, as it were. People have a range of ways of thinking and feeling and identifying. And I think my broad perspective or framework is that that we need that diversity really needs to be respected. If people feel passionately strongly about a certain identity, then one needs to respect that. And the judgmentality on the questions of identity is really the problematic thing. So how do you create a space which is as respectful of diversity as possible is really the question. And I think the challenge for all of us is how to be as non-judgmental as possible. How do we say that it's okay, there's a diversity, and the diversity has to be accepted and has to flourish. And I think it's a challenge which we all will continuously face. And uh, judgmentality comes very easy to people, right? The first thing which comes to everybody's mind is to judge somebody else. And so to get outside that framework and allow for that acceptance of difference is, I think, the challenge.
Thank you for that. And also, I asked this question because the law, as itself in its language, is also like it isn't exclusionary, although Mayur Suresh has given us another way of looking at it, extremely different. And so it just rebukes Ujjwal Kumar Singh and everyone else in the entire thing. So, um, thank you for coming. I have this running joke among like my friends that law is a man, and I just feel it sometimes that it is. I mean, and when you talk about law in a way that it also caters to the public and these conversations that happen, and especially through affidavits and etc., how law also becomes a means of talking back to the state is what I came to understand only after maybe when I did my master's. So thank you so much for coming, and thank you. And I know everybody that this panel was not very inclusionary. It was not at all inclusionary. And I promise that other panels which we would do will have inclusion, and it'll be let's keep the conversation going.
Yeah, just on that point, I think the idea was we would really want to get our colleague Ponni in on the discussion, and just time-wise, logistics-wise, it didn't work. And we felt that sense of a lack as well, because the grouping which we represented in the Delhi High Court as well as Supreme Court was called Voices Against 377, and the coalition of child rights, women's rights, and LGBT groups. So it was very important to have that diversity in a discussion. So we felt that, I mean, trans people should be at the table, lesbian women should be at the table, and that's the only way you can create a more of an inclusive space. And hopefully, I mean, in other discussions we can have you can have another discussion with Pony and others, and get a different perspective, different angle, as it were. And I think as you said, it's not the end of the conversation, it's the beginning of the conversation. So yeah, thank you.
Thank you so much. Thank you both of you. And
Personally, look forward to future conversations.
Yeah.
sure. Thank you. Thank you everyone for coming. If you have any doubts, any questions that you wanted to ask, you can mail me. I can mail them. And let's just keep talking about this. Thank you for being such a wonderful audience, and 170 people retained. So I mean, we have won this. Thank you so much.
Bye bye.
Bye bye everybody. Bye.